Welcome back. We're continuing the Winslow Jr. case. We again have the alleged victims, Jane Doe number 1 and Jane Doe number 2. Now, both of them had some issues with identifying the defendant's vehicle. Now, if you recall, he had a black H2 Hummer, but when they were questioned about it, both of them had some issues as to identifying it. I believe that one of the alleged victims believed that it was a Jeep. Let's take a listen to what Jane Doe number 1 had to say on the stand when asked about this very topic. Now that we've got your point as a prosecutor, or former prosecutor, sorry, we also are joined by Judge Birmingham. How are you doing, Your Honor?
I'm doing very well. It's good to see you again.
Great, good to see you as well. Now, maybe it's because the NBA Finals are up and my team's playing today, but I'm thinking you don't win a game by just scoring 100 points flat out. It's 2 buckets here, it's a free throw here, it's a 3-point there. I agree with Jason. Maybe this isn't the Hail Mary end of the game shot, but maybe it's just a free throw shot, 1 point to try to get you towards the victory.
That could be a good way to look at it, and I sure wish I was talking about my Dallas Mavericks in the postseason, but I'm not. But yeah, I mean, you know, if obviously they're not going to say he should be found not guilty because she can't remember it's a Jeep. They're going to be saying things like, if she's not clear on this detail and not clear on this other detail, then how can we really believe her beyond a reasonable doubt? Remember, they're only trying to create reasonable doubt. They're not trying to prove his innocence necessarily, just to create reasonable doubt. And it's kind of like death by paper cuts, or you know, those 15-foot pull-up jumpers or something like that. Enough of them might win the game for you.
Exactly. We're actually going to shift gears now. We're actually live in the court. I believe this is a forensic nurse talking about, on direct, Jane Doe number 2. So just for our jurors, we're hearing this questioning about the redness of the vaginal area. Why is this and how could this have come up? So our understanding is that the reason why the attorney is going into this is because while the judge has made the decision that they cannot bring up the consensual sex that the alleged victim said they had 2 to 3 days prior to this testing that was not Kellen Winslow Jr., they are allowed to ask questions to inquire as to whether or not the redness or the bruising or whatever was observed could have been consensual sex days prior. Now, the judge is going to have a hearing after this testimony, I'm assuming, to decide whether or not that testimony about the consensual sex can come in. Now, I'm going to first go to you, Judge Birmingham. As we kind of wait for this ruling to figure out what's what, I guess, how will that hearing work out would be my question, since you're the judge on the show today.
Well, there is this is a rape shield issue that you're talking about, and when you have a rape shield issue, if there is an explanation for the medical finding on a case like this, then you are able to get into sexual conduct of the victim. Otherwise, you're not allowed to get into the sexual conduct of the victim. So that's what they're talking about. There's some medical findings, and they're going to see if there's any other explanation for the medical findings other than this sexual assault. Obviously, if there was sexual activity 2 days prior, that might explain it, and the judge may let it in at that point.
All right, and Jason, I know you're leaving with us soon, but I'm going to give you the final word before you do, just in brief 30 seconds, 45. As they're kind of flirting with this sexual rape shield law, do you think it's going to, actually, simple answer, do you think it's going to come in that she had sex prior to?
I do think it's going to come in. And I think this witness, I think the defense attorney did a very nice job of eliciting that testimony. Notice she really wasn't attacking her on her skill as a forensic person.
Completely understand. And I started to cut you off, but we'll be back after this break. So we're back again as the defense attorney is settling himself down. Judge, I want to bring you on and ask some questions here. You hinted at and you spoke about the rape shield laws. Are we going to be bumping into that a lot as we're asking questions of different alleged victims who are accusing him of rape?
It's going to be relevant potentially in any type of sexual assault case. I mean, the rape shield laws basically say that a victim's sexual history is not admissible for any purpose whatsoever, and that's why they were enacted. There are a few limited exceptions across this country. The most common one is that they might be admissible, the previous sexual conduct, in order to explain medical findings. So that's why you're hearing this. It's relevant. It's going to come up in every single sexual assault trial that there is, especially when the defense is going to be consent.
Yeah, exactly. And if he's arguing consent and these bruises or injuries are from someone else, again, I think it goes towards the idea that he didn't rape her and that the sex was consensual.
Right.
Do you know the factors by which the judge might be deciding on whether or not they can go into her previous history, or is it just, if you can raise it by a preponderance of the evidence, that's enough? Or is there something more that needs to be heard from this witness?
I think that, fundamentally what you're looking for is there in the minds of the jurors the idea that medical findings are consistent with sexual assault? And if there is, then if there's anything to rebut that finding, and in this case, what they're talking about is a previous sexual relationship that could explain those medical findings, then it's coming in. I mean, it's really not that hard of an analysis. So that's what you're hearing. You're also getting some really good things from this witness, and you're seeing this lawyer cross-examine her about not just for the rape shield purposes, but also the victim says a crime happened a certain way. If she's to be believed, then there should be physical remnants of how she said it happened. In this case, there should be bruising around the neck, according to the defense attorney. And this witness didn't find him. So you're seeing the way that a sexual assault nurse is used really for both sides in this particular case.
Exactly. And she's still in the stand, so let's hear what she has to say. So Judge Birmingham, we've heard this forensic nurse now testify, and it appears that the prosecution has decided not to give any redirect. As you've heard this testimony lay out, what nuggets or what information do you believe we should garner from this witness?
I think it's important to remember why a SANE nurse or a sexual assault nurse is called. They're really called for 5 reasons. Number 1, what was the condition of the victim? Number 2, what did the victim say? Number 3, what were the condition of the clothes? Number 4, toxicology. And of course, number 5, the beginning of the chain of the custody. So that's why she was called. You have to consider whether or not what the victim says is consistent with the findings. And I think one of the things that you're going to hear from the defense is if Kellen Winslow strangled her for 1 to 2 minutes, there would be some finding. What the prosecutors are going to pull from that one nugget they're going to pull from that is in 50% of the strangulation cases, there are no findings. Yeah.
Now, I always find this to be a dangerous argument. I don't think that anyone should use it. But playing devil's advocate, he's an NFL player. And I know a lot of my clients say, if I had done it, she would have had serious injuries. I'm assuming that a former NFL player is much stronger than the average person. So I think it might be consistent with the defense attorney's argument that if this did happen the way it happened, they would have seen injuries. I understand that 50% of strangulations don't show injuries, but they're not by former NFL players.
Well, that's true. And what we have to remember here is what exactly did she say about how this happened? Did she say that he was squeezing as hard as he possibly could for a minute? Did she lose consciousness? She said there was some impact on her voice. So you got to consider that. Aside from that, you are going to, if you're a juror, be thinking, man, this guy is an extraordinary athlete. NFL athletes are extraordinary. He's big, he's strong, he was a tight end. I mean, those are things that jurors are going to be considering for sure.
Yeah, I think we're back in court now. Let's take a look at what's going on. So Judge Birmingham, we heard some interesting stuff from Catalina Pierce, the investigator from the DA's office, describing what she had perceived and heard from the complaining witness or the alleged victim. I know in the past we were talking about this potential theory that the defense is throwing out that this is a money grab. I think we just heard there that she did in fact know that he was a famous football player, or that his father was a famous football player who played for the San Diego Chargers. What do you make of this whole, this is a money grab, they're all making it up type of defense?
Well, I would say that if you are alleging this is a money grab, then this is pretty devastating testimony if you believe the investigator who says that Jane Doe didn't even know who he was until after the allegation was made. If she knew who it was before, then maybe, there's some basis of knowledge that she has to try to go get some money. But if she had no idea who she was, that he was a famous football player with potentially some money in it, well, then that kind of defeats the idea. I would say, if she didn't learn about it until after she made the allegation. So this is pretty good evidence for the state, if it's to be believed.
Yeah, it doesn't seem to be a stretch, and maybe I'm being a bit of an ageist here. I think it cuts the other way, that the allegations might be that he preyed upon older women so that they wouldn't know who he was. Maybe if it was someone closer in age to him, they would have known. I don't know how that plays out. Judge Birmingham, I know we're leaving soon. Both you and I are signing off, but I want to give you the final word as to how you see this case going thus far.
Well, this is a case that's being laid out witness by witness, and I think the sheer volume is going to be hard for the defense to overcome. And here's the other thing. Consensual sexual encounters don't oftentimes happen between strangers, And that's basically what the defense is in this case.
I hear you. And now, Judge, I want to thank you again for joining us today. I'll be back here tomorrow from 12 to 3. We're again going to be covering this case of Kellen Winslow Jr. Gavel to gavel here, the Law and Crime Trial Network.